of law in one case, and you come along later in time, a week later, a month later, a year later, 100 years later, and the facts of your case are similar to the facts of the other case, the earlier case, and the law that you're standing on, the law that you say was violated, is the same as the law that was argued in the other case, then the principle of law laid down in the earlier case applies to you. It's not a bad doctrine. It's called case law and precedent. If the issue's already been settled, you know, it's been settled. You need to have things predictable in our country, okay? So what happened here? What did the federal court say in our case? They said, golly, we're constrained. I almost apologize. They said, we're constrained. The Supreme Court laid down a principle of law in 1979 and in 1984 in two cases. The principle of law that the Supreme Court laid down is this: government doesn't have to listen or respond to the people, to their petitions. And the court said in our case, if the government doesn't have to listen or respond because the Supreme Court said so, then you don't have the right to withdraw your support until they do. End of case. What were the two cases that they relied on in our case? Our case was We the People versus the United States. What were the two cases? Were the facts of our case the same as the facts of those two cases? That was the law we were arguing, the same as the law that was argued in those early cases? Let's take a look. The first case came out of Arkansas. The second case came out of Minnesota. In the Arkansas case, the state legislature passed legislation that said public employees of this state, if you have on-the-job related, employment-related grievances, you must submit them as individual employees to your public employer. You cannot form an association and have it submit the grievances. And so you had public highway workers in Arkansas who formed an association, and they submitted their on-the-job related, employment-related grievances to their public employers, and the state said, we don't have to listen or respond to you. If you submit them individually to your public employer, you cannot form an association and have it submit the grievances. And so you had public highway workers in Arkansas who formed an association, and they submitted their on-the-job related, employment-related grievances to their public employers, and the state said, we don't have to listen or respond to you. If you submit them individually, as the state law requires, we will respond. But we don't even have to recognize this association. That case went all the way to the Supreme Court, and the Supreme Court said, in this context, the government does not have to listen or respond to the people, okay? To the people's petitions. The other case came out of Minnesota. What were the facts there? The state of Minnesota passed legislation that said public employees of this state, if you have on-the-job related, employment-related grievances, you must submit them through your union. You can't submit them directly. Quite the converse of what was going on in Arkansas. Well, you had 6 college professors who worked for community colleges in Minnesota. And they didn't want to submit their on-the-job related, employment-related grievances through their union. They wanted to submit them directly. They called it free speech. And that case went all the way to the Supreme Court, and the Supreme Court sided with Minnesota. Now I ask you, were the facts of our case similar to the facts of any of those cases? Well, let's see. We're not public employees. These are not on-the-job related, employment-related grievances. These are grievances, violations of the Constitution of the United States of America by our federal government. All right? The facts are clearly different. What was the argument? What law were we standing on? And was it argued in those earlier cases? Because if it was, maybe the judge had a case. You know, maybe he was right. Maybe there was a principle of law laid down there that applies here. Well, what law were we standing on? We were standing on the original intent of those 10 words. The framers' intent, the historical context and purpose of those 10 words. No court had ever declared what they mean, but we laid the case out, we laid our argument out from the Magna Carta on forward. References, footnotes, etc. Backed it up. We said, this is the meaning. This is what they had in their heads. This is what those words meant at the time that they were added to the First Amendment. If government violates your rights, you can call them on it. They have an obligation to respond. If they don't, we don't recognize them anymore, and we're not going to fund them. We don't have to fund them anymore. And we said to the court, and there's absolutely nothing in American history or jurisprudence that contradicts that interpretation. So, ante up. You know, so the court, one of the judges in the United States Court of Appeals for the D.C. Circuit, Judge Rogers, Judith Rogers, she wrote a separate 9-page decision in that significant historical case. She said this, hold everything. Not only the facts different here, but I read the briefs in those earlier cases in Arkansas and Minnesota. And the argument that's before the court that is coming from us was not argued there. The law that we were arguing here was not argued back there. So obviously the stare decisis doctrine shouldn't apply, right? But she went on to say this. It's going to be interesting to see how the Supreme Court handles this case.
Yeah. Yeah.
It's going to be interesting to see how the Supreme Court handles this case. I read that, I was elated. Hallelujah. She would not have gone that far. She would not have written that had she and her law clerks not talked to the judges and the law clerks at the Supreme Court right down the street. She would not have gone that far. And so we were elated. We said, my, hallelujah, the Supreme Court's going to hear this case. They're going to have to conclude the way we conclude. You know, they're going to have to come up with the same interpretation. And we're going to prove once and for all that the government is obligated to respond, that this is an accountability clause. They're obligated to respond, and we have the right to retain our resources and support for the government if they don't. Hallelujah. There's going to be a tremendous shift of power from the government back to the people where it was meant to be in the first place. Hallelujah. Okay. And then...
We're using the term maiden name. It's Janice Rogers Brown.
Judge Rogers Brown, sorry. Judith. Okay. So we couldn't wait to get our application into the Supreme Court, right? It's called a petition for writ of certiorari. Got it in. Man, this is going to be a great day for America, right? And in one word, the Supreme Court said deny. They denied our application. What's their job? What's their job if it isn't to hold the other two branches in their constitutional places, regardless of the level of practical difficulty? What is their job but to apply the Constitution, you know, interpret the Constitution? This was a first impression case, an extraordinarily important case for the history, you know, for the future of this country. The ability of the people to hold their servant government accountable. And they don't want to hear the case. So, that's our capstone grievance. And we need a Continental Congress. So, when will the Continental Congress take place? We have a management team now. We have experts in various disciplines on our management team, national management team. We're divided on when to start it. I prefer July 4th weekend and 2 weeks or 3 weeks after that. Let's set the date. Let's make it a forcing function. We set the date, we force everything else to happen quickly, you know. But then there's those on the management team who say, wait a minute, do we really want to fix the date that quickly? Because we can't afford to leave any state out. We need 3 good delegates from every state. We've got to allow them time to do this and so forth. And so there's this disagreement in the management team. But it's my decision in the end, and I'm holding fast. Not quite ready to yield yet, but hopefully it'll be July 4th weekend and beyond. And I don't know where it's going to be, but I am intrigued by Zechariah.
Where was the original?
Philadelphia. They convened in September of '74 and reconvened in '75 and '6. Yes.
There's also a constitutional issue about who is supposed to interpret what the Constitution means. The way I understand it, the Supreme Court was never authorized to determine solely by itself what the Constitution meant. They usurped that in the Madison versus Mayberry case. And the government let it stand because it was more or less in the government, the rest of the other branches of the government let it stand because it was more or less in their favor, their decision in that case.
Yeah,
So ever since then, they said, well, we can do it because we did it, rather than we can do it because the Constitution gives us that authority.
Yeah, I think Jefferson put it this way. It's up to each branch to determine constitutionality of what it does, but that the people are the final arbiters of the Constitution. Is that a fair assessment of the way Jefferson put it, John?
Well,